From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court hears a case on California's attempt to regulate out-of-state pig farmers as the Biden administration tries to redefine who's an independent contractor. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Welcome to you both. On Tuesday, the Supreme Court heard a challenge to California's Proposition 12. This was passed by voters as an initiative in 2018, and it includes some regulations for confinement for pigs, for example. I think other animals too, but pigs are the ones that were at issue at the Supreme Court on Tuesday. And let's listen to a couple of clips of first Justice Elena Kagan and then Justice Amy Coney Barrett wrestling with this issue of how far California can go in regulating industries that don't actually do their jobs in California.
You know, we live in a divided country, and the balkanization that the framers were concerned about is surely present today, and I think that the real power of Mr. Needler's examples were, do we want to live in a world where we're constantly at each other's throats and, Texas is at war with California and California at war with Texas.
How many laws would fall? I mean, California has higher emission standards on automobiles than many other states. Does that fall?
No, absolutely not. I mean,
why?
That's entirely federalized. They have a waiver from the federal government regulates emissions, and California has a waiver from the federal government for that. If you look at the
what if they didn't? What if I understand California has some new legislation about electric cars and electric vehicles, and by 2035,
all done under waivers. But take the
okay.
Apple
Well,
example.
let's assume. I guess what I'm saying is Justice Kagan gave you the example of the firewood and the pesticide. If they have a waiver about emissions, fine. There must be many state laws that regulate extraterritoriality, outside of their territory, in the way that you are saying is impermissible. So would this have far-reaching consequences?
No, it wouldn't have far-reaching consequences.
Alicia, what's your read of how this argument went as the justices tried to struggle with this question of how much can a state regulate outside its borders? And our editorial on this issue says that something like 99% of pigs in the U.S. are raised outside of California. And the other tension is, this is what Justice Barrett is raising, is states have all kinds of laws regulating products that are bought and sold within their borders. And if this goes, what else might go?
So I wasn't very surprised by how the oral arguments went. These were actually questions that I was grappling with while reading some of the briefs on both sides. States have police powers to regulate the public health and safety in their states, and that's basically one of the justifications for laws like California's Prop 65, which requires cancer warnings. Also, as Justice Barrett alluded to, there are emissions. California maintains a higher emissions standards on automobiles, not just for CO2, but also for NOx. And that's a separate question because that is covered by the Clean Air Act, which preempts state laws, explicitly preempts state laws to regulate auto emissions and provides California a waiver. But if the Clean Air Act didn't exist and there were no explicit preemption of state laws, would California be able to set these standards? And I would argue, yes, it could, because there is a direct public health effect, especially because California has long struggled with more smog than the rest of the country due to partly geography. But the issue here, I think, is actually quite clear in this case, where California is trying to basically regulate pork production throughout the country. 99.9% of the pigs are born and raised outside of California. So it would basically have a de minimis, basically no impact on California pork production. It would purely regulate pork production in the rest of the country, and there is no public health or safety justification for this. It's really a moral crusade that was really launched by the Humane Society because it doesn't want us to eat meat, so it wants to raise the costs. But even California has conceded that its standards will not have any direct impact on human health and welfare. And at that point, it basically concedes the argument that it does not have police powers to regulate this. And so I think that this is actually a much more clear case than some other examples that the justices brought up during the oral arguments.
Yeah, I also was trying to figure out, as I was thinking about this, where exactly the lines here would be drawn. And to use another automotive example, my understanding is that California requires a special blend of gasoline. And that's something that maybe you can justify because of the effects on a local smog problem. And so if you're doing a kind of balancing, that makes a little bit of sense, even though that acts as a bit of a protectionist barrier, because you can't just sell regular old gasoline that you make in Texas to Texas specifications or to the rest of America's specifications. You can't sell that in California. On the other hand, Kim, Proposition 12 looks like it's way beyond that. I mean, I was trying to imagine another analogy, like if you took the special blend of gasoline example further and said something like any plastics that are sold in the state of California can't be made with fracked oil. I mean, there's an example where really it starts to look to me like the purpose of this is not anything local. It's not related to the health and safety or anything of the product that is being sold. The point is to reach that regulation over the border to wherever the production of the product is taking place. Or, you could have a regulation like that. Any plastic product sold in the state of California has to be made by people earning a certain minimum wage that is higher than most of the state minimum wages. You can think of all sorts of hypothetical examples like that. And then maybe you do get a problem, as Justice Kagan was talking about, of are we really going to have Texas trying to impose its regulations on the rest of the country and California trying to impose its regulations? I thought that's what the Constitution was supposed to get rid of.
Right. I mean, if you look at the constitutional doctrine at question here, which is the so-called Dormant Commerce Clause, the idea behind it is it prohibits states from imposing excessive burdens on interstate commerce. And that goes all the way back to the founding of the country, when there was a lot of worry that, states imposing tariffs on goods from other states or restricting intercourse with other states would really undermine the notion of a union of states. And regulations tend to beget retaliatory regulations. So the notion was that we needed to have a kind of harmonious system here. Now, on the face of it, it would seem that, to me, California's law very much exceeds this for all the reasons that you and Alicia just point out, in that, obviously this is an excessive burden on commerce just from the grounds that it's going to raise costs for pork producers and thereby prices for other people. It also contravenes specific state laws in other states. For instance, in Ohio, they have a law in the book that authorizes the explicit animal practices that California is banning. So it is reaching across the border and contravening other state laws in a way, even though the industries in question here do not really reside in California. So that one seems easy. But the problem and the reason everyone gets up in arms about this is that the justices on the Supreme Court are very conflicted on this question, including the conservative justices. A number of them, in particular Clarence Thomas, feels as though this particular doctrine is judge-made. They get very concerned given that it has been used, this doctrine, in the past to sort of squelch states' rights, to allow Congress to preempt sort of our federalist system in ways, in my mind, have gone overboard. So there's a balance here. And I think it's good that this discussion is bringing up that balance again. But it's one, again, in my mind, this particular law, it doesn't seem as though it should be a tough one to call.
On the point about the Dormant Commerce Clause, I will just read for the record here. This is the Commerce Clause, Article 1, Section 8. The Congress shall have power to lay and collect taxes, ... There's all sorts of other things listed. And then to regulate commerce with foreign nations and among the several states and with the Indian tribes. And the argument against the Dormant Commerce Clause is that this is a grant of power to Congress, which does not remove any power from the states. But Alicia, if the point of this was to get rid of the old fears of individual states putting border taxes and tariffs and things on each other's goods, to get rid of state protectionism, it is easy for me to imagine how states, if they are no longer allowed to do that, would try to replicate that through regulation. And so banning states from putting taxes on each other's goods, I think it's implicit that you're not allowed to do things that have basically the same effect by other means, right? The other thing that I would point out is, given the skepticism of some of these justices, particularly Clarence Thomas of the Dormant Commerce Clause doctrine, is that we also have a long history of it, right? And so whether or not you're going to go back to first principles and rewrite all the Dormant Commerce Clause doctrine is one question, or whether you're going to apply it as it has been applied in a case like this from California, is a separate question, and the justices may come down on different sides of those.
Right. I don't think we're going to throw out the Dormant Commerce Clause here. As you point out, there's about 200 years of precedent going back to the John Marshall's decision, the Ogden case, involving New York trying to erect barriers to steamboats, from New Jersey. The tricky issue here, and the California's defense is, well, we're not, as you point out, this isn't a direct protectionist regulation. We're not trying to impede products from out of state coming in to compete with California products. And that was really what the Constitution and the Commerce Clause was intended to prevent, was states from imposing tariff barriers to protect their own domestic industries. And here, California does not have really a domestic pork industry, and it's not trying to protect it. So increasingly, actually, what we're seeing with these state regulations is they're not trying to protect domestic industries. In some cases, they are. And to your point, actually, fuel regulations, it's interesting because California also has a renewable fuels mandate separate from its special blend, and that has been challenged because it actually does directly increase or impose regulatory barriers to out-of-state fuel by saying that they have higher CO2 intensity because they have to be transported into the state. The Ninth Circuit actually, in that case, ruled in favor of California, saying this was an indirect and incidental burden on interstate commerce and wasn't actually directly intended to protect its domestic industries. So you can see that the courts are really grappling with this issue now that the regulations aren't, to some extent, overtly punishing out of states for economic purposes. In this case, we're seeing increasingly these are moral crusades. These are philosophical issues. ESG. And so in this case, I think the court can apply the existing precedents quite, clearly. The Pike case several decades ago, which required, courts to weigh the local benefits against the burdens on interstate commerce. And I think it's clearly the burdens on state commerce exceed the local benefits in this case. Public health. How do you define excessive burdens on interstate commerce? That's something that the lower courts are going to continue to grapple with. And I think that it would be nice to think that the high court will help clarify these issues and maybe provide a little more guidance to the lower courts as they have to hear these kinds of cases. But I think this one is quite clear-cut based on existing precedent. We're not going to throw out the Dormant Commerce Clause, like we're not going to throw out substantive due process, which Clarence Thomas has also criticized. It's just a matter of applying the existing precedents.
I take the point that this may be a moral crusade and not one that is based on state protectionism. Though, again, it is easy to think of examples where it would be harder to know. So California, of course, is the home of the film industry, but there are a lot of shoots that now take place in other states. Other states have tried to draw those jobs and that economic activity. And so you could imagine California passing a regulation about films that are shown in California, which is ostensibly aimed at working conditions or something on film sites, but it gets pretty muddy if you start thinking about, well, is the real intent of this to get people to come back to California where the minimum wage is already $15 an hour, to take away some of those advantages for film shoots elsewhere. So Kim, I take the point that maybe this is a more clear-cut case, but it does seem like there are some difficult line-drawing problems in some of these judgments about the Dormant Commerce Clause. And we'll give you the last word on this point.
Yeah, I would just step back even further as well. We're talking about whether or not this is a moral crusade, or talking about, the technicalities of the law. I think it also needs to be viewed in the context of California, which simply is intent. And so many of its decisions have been aimed at this and made it clear its intent on essentially trying to set itself up as an alternate federal government and use the power of its market, which is the biggest in the country, to try to set the rules everywhere for everyone. And it's increasingly been trying to do this. Now, granted this is a ballot initiative, but there was no question. There was a reason the Humane Society pushed it in California, because it knew that if it was passed in that state, that it would have enormous consequences and be very hard for anyone to ignore. And so that's kind of the problem, is California increasingly using its market share and market weight to operate as a West Coast version of the federal government, only in a more sneaky fashion.